Welcome to MNT, this special episode of MNT News Network. Today we have a very special guest joining us from the United States of America, Professor Michael Foreman. Professor Michael Foreman is the director of the Civil Rights Appellate Clinic, and he is a clinical professor of law teaching at Penn State Law, the Pennsylvania State University, US. So I welcome Professor Michael Foreman to this special episode of MNT News Network today. Welcome, sir.
Thank you. I'm happy to be here, and I'm happy to be with one of my ex-students.
It's indeed a pleasure to host you today, sir. As decided today, we will be talking about the importance of reservation and affirmative action, along with the global nature of caste. So, starting with, I would just like to tell few lines about Professor Foreman. However, they are not sufficient to cover his entire identity, but still, I will try. So, Professor Foreman is currently, as I told you, director of the Civil Rights Appellate Clinic at Penn State Law. He is a clinical professor of law there, and he is actively engaged in appellate level litigation before the United States Supreme Court and different courts of appeal in the United States. Before joining Penn State, Professor Foreman worked with the Lawyers Committee of Civil Rights. Professor Foreman has been the Deputy General Counsel for the US Commission of Civil Rights, where he served as the lead attorney, which was investigating the voting irregularities in the 2000 presidential election in the United States. Professor Foreman is frequently called upon to testify before the Congress. Congress is like the parliament of which we have in India, so the American Congress, and he is frequently called there to testify on issues of civil rights and employment discrimination and the impact of Supreme Court decisions which affect these issues. So he teaches advanced employment discrimination and employment relationship courses. I had the privilege to take both his courses, and from these courses, and also I was also a part of his clinic, and from there I witnessed his passion for civil rights, equality, and social justice. And under his leadership, we all worked on a US Supreme Court case on an employment discrimination aspect. Whenever I get a chance, I talk to him and take his guidance on different aspects of constitutional law and equality. Recently, when the Supreme Court of India was hearing the EWS case, I took his comments on that also. So it is his helpful. It is very helpful by nature. And sir, I thank you for coming to MNT News Network today, and it is indeed a pleasure to have you here. And thank you so much for joining and giving your time for the cause of equality in India, sir. Thank you so much.
Well, thank you for having me and for raising this very important issue.
So, Professor Foreman, now moving towards the interview, the first question which I would like to ask you is about your clinic. How does your clinic function, and what are the types of cases that you deal in? And please tell us something about some of the discrimination or affirmative action cases that you have fought. And lastly, please tell us, why did you choose this field of equality, this field of anti-discrimination as your career? Please, Professor Foreman.
Well, thank you. First, let's talk a little bit about my clinic. You were in my clinic, so you have a good feel for. But the idea of my civil rights clinic was within the law school to give students an opportunity to see what it would be like to working in a law firm that worked on appellate litigation cases. Appellate litigation cases are those that they've already gone to trial or they were dismissed and they're up in the appellate courts and or going to the Supreme Court of the United States. And the idea was to have a small group of students that to be able to actually practice and work on these type of cases. And we've represented clients. We do another practice. I don't know if it's the same as in India, but you can file what is called an amicus brief on behalf of a party where you're not actually in the case, but you are giving the court your idea of what the rule of law should look like. And we started it 13 years ago. We've had cases in the Supreme Court, in the appellate courts. We had one that I had the opportunity to argue in the U.S. Supreme Court. Unfortunately, we lost in a 5-4 vote, but then Justice Ginsburg read her dissent from the bench, which at least gave us some consolation that we were on the right side and we're making the right arguments. What we work on sort of depends on what's percolating up through the legal system here in the United States. I think the best example this semester, I call it my religious discrimination semester, because we dealt with two separate cases. One in the U.S. Court of Appeals for the Seventh Circuit, which is a lower level appellate court. And the issue there is an exception to the discrimination laws. And in the United States, there's a law that says it's unlawful to discriminate because of religion. And one of the issues comes up is this concept called the quote ministerial exception. And employers, particularly religious schools or religious employers, will argue that their employees are a minister. And if you're deemed a minister under the law, then you're exempt from any of the civil rights laws based upon race, sex, national origin. So we worked on that case in early January, and then just in March we filed a case in the United States Supreme Court. We didn't file a case; we filed an amicus brief on behalf of neither party. But the issue was, how far does an employer have to go to accommodate an employee's religious beliefs? And there is a standard out there that is called the Hardison standard that says no more than the minimum harm, because the concern is if you provided too much accommodation for an employee, then you're actually establishing religion, which would be a violation of our Constitution. So there's this delicate balance, and we filed a brief on neither side, basically trying to tell the court there's a real delicate balancing. We need to adapt. We need to provide meaningful accommodation for religious beliefs, but we can't go too far, or it will cause establishment concerns. And that if there is harm to the third party, other employees, let's say, for instance, I have to take every Sunday off, then some other employee is going to have to work every Sunday. And how do you balance that hardship on the other employees? That needs to be a relevant consideration. So that's just an example of the type of cases that we handle.
And sir, can you please tell us some of the equality or anti-discrimination or affirmative action cases which you have handled?
I've done less here. I've been involved in background work on the case that's currently pending in front of the U.S. Supreme Court, the diversity case against Harvard and the University of North Carolina. But when I was at the Lawyers Committee, I was involved in numerous cases that I represented the Black highway patrolman for the state of Mississippi, where there was an affirmative action program implemented by the court. I represented Buffalo, Black firefighters and police officers up there. In the New York City, there's a case called Local 28, which we may talk about going forward, which was discrimination against the union for not letting Black and Hispanic workers get their fair share of the work, the building work that was happening up in New York City. And for instance, in the Mississippi case, the court entered a 1-to-1 hiring order. We were able to establish that there was past discrimination. In fact, there had never been a Black highway patrol officer for the state of Mississippi when the case started. And we proved there was intentional discrimination. And then under affirmative action requirements, the court entered a 1-to-1 hiring order saying for each white officer you hired, you had to hire a Black officer until they developed a selection system that did not discriminate based upon race. And that is comparable to the type of cases I did in Buffalo, I did in New Jersey, I did in a couple others, where you are either establishing through a consent order or a court order, and then having an affirmative action program. And then going back to Mississippi at one point, then there's an issue of when does it become unconstitutional and that's some of our discussion we're going to have today. Is you can have an affirmative action program under existing United States laws, but there are very serious constraints in how you do it, how long it can run, what it needs to look like, etc. Uh, I
Yeah.
think that gives you a little bit of the background.
Yeah. Thank you so much for sharing that, sir. So let's start from the basic. Sir, in 2004, you wrote an article, The Continuing Relevance of Race, Remedies, and Programs in Integrating the Nation's Workforce. And today we are talking about affirmative action, or this remedy to cure inequality. In today's session, we are talking about that. So, starting with what, according to you, is the meaning of affirmative action, so that every common person in India can know what affirmative action actually means in the United States, and why do you think that there is a need for affirmative action when law on paper says that everyone is equal? That is my question to you, sir.
Um, and actually, the way you pose the question is a perfect example of the debate in the United States, because we have the law, Title VII of Civil Rights Act 1964, that says it's unlawful to discriminate based upon race, religion, national origin, sex, etc. And it says it's unlawful to discriminate because of that. Uh, Opponents of affirmative action argue that under that law, if I engage in affirmative action, I am actually acting because of race, and therefore it would be a violation of Title VII. The other side of the coin is the civil rights laws were passed at that point to aid Black Americans who had been denied opportunities in our society. And the Supreme Court, in the Weber decision, said, it would be very odd to have a law that was passed to enable Blacks to become a meaningful part of our workforce, and then say you cannot engage in affirmative action. So that was one of the original decisions that recognized affirmative action in employment is voluntary, is legal, depending on how it's done. I don't want to get too much into the weeds here, but I think for your audience, it is important to understand our perspective here in the United States, that when you talk about the term affirmative action, what you're doing is doing something beyond providing equality. The equal treatment, affirmative action is one step beyond that. So in the United States, anytime you look at an employer-based affirmative action program, there's a couple major decision points. The very first one is, who are you? And when I say who are you, what I'm talking about is, what do you look like as an employer? Because if you are a private employer, there's a different set of legal standards that apply as opposed to a public employer. If you're a governmental employer, what happens is the US Constitution comes in and there are different requirements there. So that's the first thing you need to analyze: who's doing the affirmative action. Second big issue is why as an employer are you doing it? Are you doing it for pure affirmative action purposes, or are you doing it for diversity issues? And again, diversity is a term that can be misunderstood. Diversity in the law is, you are not doing it to remedy past discrimination. You are doing it to maintain your current workforce so that your workforce would look like the society you're hiring from. There are different legal standards that apply there. And then the third major point is, what are you doing? And the Supreme Court of the United States has been very consistent. What is the scope? Are you doing it based upon race? Are you doing it based upon national origin? What is the time frame? The court says we don't want these things to go on in perpetuity. And third is, where does the burden of the affirmative action program fall? For instance, if it is a layoff situation and you decide I'm keeping the African American because of an affirmative action program, the Supreme Court says, well, wait a minute, that burden falls on the white employee who is in fact being laid off. Whereas if it's a hiring situation, the burden is much more diverse. Um, and and so they're the three big things that you need to be concerned with. Um, Now, going back to if you're a private employer, if you're a major US corporation and you want to engage in affirmative action, the requirements are you must have a manifest quote, and that's a term for the imbalance in the workplace. What it really means is statistically, your workforce looks bad. You don't have blacks, you don't have women, etc. Second, you need to show that it's not unnecessarily trampling the rights of other workers. That is no absolute bar, which in our country is basically you can't have quotas. You can have goals, but you can't have quotas, and it shouldn't be in existence longer than necessary to remedy the past discrimination. Now, when we turn to diversity, the Supreme Court has never recognized that that is an interest for doing race-based hiring, firing, etc. in the employment context. They've done it in the educational context, and if you've been watching United States law, one of the big cases in front of the Supreme Court is against Harvard University and the University of North Carolina, and they have a diversity program for the admission of their students that's being challenged as being unconstitutional. And their rationale is we're doing it for diversity purposes. We want our school to reflect the whole society. And therefore, we are taking diversity efforts. That's what the Supreme Court has in front of it. But it has not translated to the employment setting yet. So there's all kinds of these little moving parts. I'm just going to stop here,
Yeah.
but that's sort of a complicated overview. But that's generally where we are.
Yeah. We got your point, sir. And as you told us that affirmative action, the standard of affirmative action is different if you see a private and a public setting. And you also shed light upon the different aspects of affirmative action in the employment context. So, in the employment context, our next question is if, for example, a particular community such as blacks, they are not adequately represented in a particular institution, then can a court in America order affirmative action in an organization? That is our other question, sir.
Yeah, and actually, I think that's a great question. It goes back to one of your first questions. I'll use the Mississippi
Yeah.
example. That is a classic example. When the case was started, there was um,
Um,
there had never
there.
been a black. Can you hear me?
Yeah, I can hear you now. Yeah.
I faded out for 1 second there.
Yeah, no problem.
There never been a black highway patrolman. A lawsuit was filed that says it's unlawful to discriminate based upon race. It went to trial, and we were able to convince the judge at that point that this was intentional race-based discrimination, that it violated Title VII of the Civil Rights Act of 1991. So then we went to the court and say, one, you need to provide a remedy. And the law allows you to do affirmative action as a remedy. And we said that remedy needs to be correcting this imbalance, which is how we got the court to say, for every white that's hired, you need to hire a black, with the caveat it would only be in existence until the Mississippi Highway Patrol developed a process that was a fair selection process that did not screen out African Americans. And that process went on for literally years until they developed a process that in fact was fair to everyone and was not screening out African Americans. And so that's a classic example of affirmative action, and the law allows you to do that. Now, let's take it one step further. Where some of the controversy comes in is, let's take an employer that has, bad numbers. They don't have blacks. They don't have enough women. Uh, they don't want to be sued and go through the legal process, so they enter into a consent decree, which is basically a contract between the employer and employees, or whoever's representing employees, to say, we are going to do an affirmative action program. We're going to encourage more women to apply, more blacks to apply. And then you enter into a consent decree, which is a different type of affirmative action program. And the courts have said that is an acceptable way of doing that. So the law does allow you to do that. Now, if you want to jump ahead to our U.S. Supreme Court with Chief Justice Roberts and some of the other, there's a view in the Supreme Court that is the appropriate use of affirmative action in the employment setting to redress past discrimination in your workplace. And I want to focus on that. Is the Supreme Court has said an employer can't just come in and say, we want to do the right thing. There's been societal discrimination across our country, and we're going to do an affirmative action program to correct the societal discrimination. Rather, the court has said, you need to look at your workplace, where you're working and what your past history is, and then you could justify it based upon your past history of discrimination.
Right. So essentially, what Professor Foreman said is that, like we in India have the reservation and promotion system, in which there is affirmative action to describe of a reservation in which few certain number of seats are fixed for the scheduled caste, scheduled tribes in the higher rungs of the administration. In a similar manner, not exactly in the same, in a similar manner, they have the affirmative action program in America, wherein, if, for example, if blacks are not adequately represented in a particular stage or in a particular stage of the administration at a particular level of administration, then the court can order affirmative action and make the blacks more represented at that part. So thank you so much for sharing that, sir. So our next question to you is that Professor Foreman, you have been teaching at Penn State Law for more than a decade now. And before that, you have also been a Warsetine Fellow at Harvard Law School, where you counsel students about public services. Now, given, and as we all know, that Penn State Law takes a lot of LLM students come to Penn State from different parts of the world. So you are working in a leading global law university who takes students from different parts of the globe. So how is your experience, and do you feel that having students from different communities or from different nationalities increases diversity and makes the classroom experience more vibrant? What is your take on that, sir? How is your experience?
My view is absolutely, having done it, and I come from both settings. One, in the educational setting, in the classroom, and two, once you're out of the classroom and you're in the workplace, having diverse views, diverse backgrounds, people coming at whatever issues being confronted, whether it's marketing a product or representing somebody as a lawyer, that those different perspectives make the end product better across the board. And I know, particularly in my employment, I teach employment discrimination class, having students from diverse backgrounds in different countries that have different discrimination laws brings a different perspective as to what the United States law, one, looks like, and two, what it possibly should look like or what it shouldn't look like. And then when you're in the workplace, having those different views is, to me, extremely important. And it's just not me personally. When the one of the seminal cases is the Grutter versus the University of Michigan case, which is an education case, and University of Michigan Law School and undergraduate school had diversity programs to say we want to have a diverse student body. Uh, all the Fortune, not all the Fortune 500 companies filed a brief saying it is extremely important in the educational setting to have those diverse. The U.S. military filed a brief saying having diversity within the military is important, and the Supreme Court, I think, understood that point, because they said diversity in education is a, quote, compelling governmental interest, that you can have limited use of race in order to have a diverse population. So yeah, I've seen it from both sides, but it's just not me. I think most large corporations now recognize if you're going to work in a global economy, then you want views respecting that global economy, and not sort of a one person, one race, one gender dynamic driving your decision making processes.
Yeah. So in a similar manner, I would like to tell you, sir, that we in India also have reservation, which is form of an affirmative action in educational institution. So the students who belong to the marginalized sections, such as the scheduled caste, scheduled tribe, and the other backward classes, so seats are reserved for them so that they can reach these educational institutions and get education there. This is also like a diversity program, because in absence of that reservation scheme, these marginalized students will not be able to reach these institutions, these educational institutions. So in a similar way, like you have affirmative action in the educational setting in United States, we have a similar, not the same here as well, but a similar reservation in educational institutions as well, and we have it from bachelor's to the PhD level here in India, sir. So but whenever we talk about reservation, or whenever we talk about affirmative action, a question always arises, that many people say that reservation, or for that affirmative action, that reduces the efficiency of the institution where it is implemented. So when these students who belong to marginalized communities, they reach universities and colleges, they in India, they are many a times they are taunted for being less meritorious. And even the Indian Supreme Court has considered, and they view affirmative action, or they view reservation as inhibiting efficiency of the organization. There are many judgments of the Supreme Court of India, sir. What is your view on this? How do you feel? What is your take, and how do you feel that how does reservation, or how does affirmative action affect the efficiency of that particular institution?
I think it makes you a more efficient corporation, a better. There may be some growing pains to be in incorporating everyone into the process, and my answer is going to seem simplistic, but when you have the Fortune 500 companies in the United States filing a brief in the United States Supreme Court saying diversity is important, I'd like to say they're doing it for good moral reasons, and I hope they are, but they're also doing it for good business reasons. They know it makes them a better, more profitable, stronger corporation. So I think the data out there makes it a more efficient corporation, a more efficient business, a more efficient educational program. When I'm getting views from across the world in my employment discrimination, that gives my students, my U.S. students, a better understanding than a person that didn't have that diversity background.
Yeah. Yeah. So now we would like to come up to the next part of the interview, in which we'll be talking about Title 7 of the Civil Rights Act 1964. You are an expert in that, we know, sir. But we were just want you to introduce Title 7 of the Civil Rights Act. What does it say? And what are the penalties in Title 7? And can you just give an overview of Title 7 to our viewers so they can know about this law?
Yeah, and I'll do it very quickly because we've talked about some of it, but it was a law that was passed in 1964. And the idea was that let's prohibit discrimination in employment based upon race, sex, national origin, religion, color, that those characteristics should not be in the equation in hiring. So Title VII says it's unlawful for an employer to discriminate because of those characteristics. It applies to employers that have 15 or more employees, so it doesn't hit the really small shops, but for larger corporation it does. And what it provides, that if you're a victim of discrimination, you can go to the federal agency, which would be the Equal Employment Opportunity Commission, and file a charge, or you can hire a private attorney who can pursue a claim through Title VII. And if you ultimately prove to the judge and or jury that it was unlawful discrimination, let's say you did not get a promotion, and it was because of your race, and you prove that it was in fact a promotion, the court at the end can order that you be promoted into the job you would have had, and they can award you back pay for the money you lost when you were not promoted. And the same thing would happen in a hiring, or they fire me because of my race. I could be ordered to rehire the person as an employer and pay all their lost wages. There is a provision of the law that says if it's particularly bad, you can get punitive damages because to basically punish the employer based upon the size of the employer. It can be up to $300,000 worth of punitive. And then the other aspect is compensatory damages, that if it's particularly bad, I can get damages to compensate the person for emotional pain and suffering because they were a victim of this discrimination. So it provides what they call a make whole. The idea is to make the person whole and put them to where they should have been, but for the discrimination is sort of a broad overview.
Okay. So, sir, our next question, like you told us about Title VII of the Civil Rights Act, similarly, there is a concept called disparate impact discrimination uh, in the United States. For example, if the government, or if the United States government, or if any government comes up, or if a state government, they come up with a particular requirement which affects, or which disproportionately affects members of the black community or other marginalized group, then in that case the US Supreme Court or the other courts in the United States, they can declare that particular requirement to be unconstitutional or to be against the law. Can you explain to our viewers this disparate impact discrimination which is recognized in the United States, sir?
Yeah, and again, I'll use an example because I think it's more understanding, but it is basically statistical proof of discrimination. That we're not in my first example, Title VII, that's intentional discrimination. I did it because of race, sex, national origin. In disparate impact, the law isn't concerned about the intent, but rather the impact. And to give you, I think, the classic example, one of the first examples that ultimately went up through to the Supreme Court was a case where the employers, and particularly police departments, had height and weight requirements for their the idea was, well, you need to be so big and so strong to be able to be a police officer. And they actually had height and weight requirements. But when you looked at what the impact of that was, it was screening out 99% of all women. Not intentionally, supposedly not intentionally, but in fact it did. So no women were becoming, and the law says in those cases, if you can prove that it had a disparate impact, meaning that it is statistically screening out a protected class, whether there it was sex, it could be race, it could be national origin, then you turn to the employer and say, you need to show us business necessity, that this is the only way you can really screen and select people. And in those cases, it was very clear, well, you could do tests to determine whether the person could actually make arrest, carry a fire hose, do anything like that. And you don't need to use these artificial means. So it's a way of getting to artificial sort of barriers to discrimination that may not be intentional. Um, and just sort of tying it back to affirmative action, that's one of the requirements when I look at my workforce. If I'm an employer and I look at my workforce and I say I may need an affirmative action program, the first thing I'm going to look at is there a manifest imbalance in the workforce? Meaning, is statistically, do I have a problem with the number of women, number of blacks, number of Hispanics, etc.? And look at that to do a statistical analysis, and then that becomes the first basis of whether I have justification for even starting to do an affirmative action program.
Yeah. Our last question, which with respect to this part of the interview, is that, for example, if someone has been discriminated against in America and he does not have the money to pursue his case, and he feels that he has been discriminated, so what remedy does he have?
A good question. It's a problem with many parts of the law. In the United States, there are, for instance, if I'm believe I've been discriminated against, I can go to the Equal Employment Opportunity Commission, and there are state and smaller regulatory agencies that do the same thing, and I can file a complaint with them. And if they believe it's an appropriate case, they can actually take that case forward and litigate it on my behalf without me having to hire an attorney. They cannot do all cases, but if they think it is a significant case, they can move forward. There is a provision in the law that an individual could ask for an appointment of attorney, but it is a pretty stringent standard in order for an attorney to be appointed in those type, because these are not criminal cases, for an attorney to be appointed to represent in a civil case like that. And there are organizations, my previous organization, the Lawyers Committee for Civil Rights Under Law, we would take on cases where people did not have money to hire an attorney and could not go forward, and we would step in and provide an attorney for them in cases. But again, we had limited capacity. The NAACP does the same thing. There are a lot of advocacy groups in the, say, the disability area, the race area, the gender area, that can provide some ability to move your case forward.
Yeah.
But there's no guarantee that that's going to happen.
Okay. So what Professor Foreman basically told us is that if someone in America does not have money to pursue his case, then they have the Equal Opportunity Employment Commission, where you can first take your case, and if they feel that you have been discriminated against, then then they will fight your case then on your behalf. They will file your case. That means that they will actually fight for your rights. But we don't have such type of an organization in India, sir. We don't have a comparable law like you have the Title 7 to the Civil Rights Act 1964. So similar law which provides for such damages for discriminating is absent in India. And we also do not have the Equal Opportunity Employment Commission like you have in the United States. So from this, we move to the next part of our interview, which is the global nature of caste. Since the topic for today is global nature of caste and the employment of and the importance of reservation and affirmative action. So, Professor Foreman, my question to you is that, do you think caste has reached United States on basis of what you are reading in newspapers and in general day-to-day life? And if yes, we would like to know about some of the instances of caste-based discrimination which you know or which you have read about.
It's definitely reached the United States. The city of Seattle, Washington, just passed a law that says it's unlawful to discriminate because of caste, and they have a definition of what caste means. There are been several lawsuits. Usually, the one was against Cisco Systems and some of the big tech companies, where the allegations were people who were viewed of a lower caste were assigned worse working conditions or paid less. And there are some cases filed challenging that under this law we've been talking about, Title VII of the Civil Rights Act. The issue is, so far the courts have not really recognized that caste-based discrimination is covered under Title VII. And part of the rationale is, if you go to Title VII, it says it's unlawful to discriminate because of race, because of national origin, because of religion. While caste may have some aspects of each of those, it's basically within the India population, you're the same national origin, you're same race, etc., and therefore it's not a neat fit within those laws, and there haven't been many court cases that have actually found that caste-based discrimination is the same as discriminating based upon race. So there's a fairly big gap there, which is the reason you see, like, the city of Seattle said, we're going to answer that question. We're going to add caste to our law. And their specific law is interesting, in that they have an actual definition of caste is a system of rigid social stratification characterized by hereditary status and social barriers sanctioned by custom, law, or religion. And then and what they do is simply add caste to race, sex, national origin. So I think we're seeing it over here. We are going to see more cases like that. And I know the Equal Opportunity Commission has been approached to say, should the federal law be amended to address this issue? But there's not anything percolating aggressively right now on the federal sector. I think you're going to see it more on a state and or local level, like we saw in Seattle, Washington.
Yeah. So since your style of teaching in classroom is a Socratic method in which you give a lot of illustration to students and students have to think about that. So today I have one illustration for you and we would like to know your answer on that. For example, if someone from a lower caste community in India is discriminated against by an upper caste person in an employment context while working, for example, in a private company, then what all remedies does he have in the American context? What all remedies does he have? How can he take his case forward?
Well, if he has an aggressive attorney, I think the aggressive attorney would try to argue that when Title VII says race discrimination, national origin, except color, etc., that caste is functionally the equivalent of that, and it should be covered by that federal civil rights law. It's, in one sense, the argument would be comparable for a long time in the United States, because our law says it's unlawful to discriminate because of sex. And the issue was, if I am gay, if I'm discriminated against because of my sexual orientation or because of my transgender status, is that sex discrimination? And many courts initially said, no, that has to be specifically specified. Well, we had a case that went to the U.S. Supreme Court 2 terms ago, and the Supreme Court says, when you discriminate because of somebody's gender identity or because sexual orientation, that is functionally the same as sex discrimination, so it's covered under sex. I think the argument would be, when I am discriminating against someone because of their view of being in a lower caste, that has either race implications, religious implications, or national origin implications, and therefore that is functionally the equivalent of discriminating based upon those characteristics, and therefore it would be covered. I would try that first, um, and then beyond that, it becomes hard to challenge that in the United States.
And how does this situation change if the person, for example, is living in Seattle City, where caste is recognized as a ground of discrimination?
I'm not sure I understand.
Yeah.
I mean,
So,
if you're in Seattle, it doesn't matter what the Caste recommends. It says it's unlawful to consider that in employment, period. So it
so
doesn't
that will be
matter what that caste system may have said or their beliefs are, uh, that would be unlawful.
so that will make it much more easier. That is what you want to say.
Yes.
Yeah. So another illustration which we want to give you is that to understand the anti-discrimination laws in India, for instance, if someone is being given caste-based or race-based slurs or abuses, what kind of liability will the person has who is giving such kind of caste-based or race-based slurs? Can he face any kind of penal liability such as imprisonment also?
In United States, no. If you have a law like the Seattle law that says it's unlawful, then you would get your fair wages, you get promoted, you get fair treatment, etc. The Seattle law does not make it a criminal prosecution. And the other sort of gap in the law where we've seen this is in like personal service contracts, whereas persons working in a home, so it's not a corporation, so they're not covered by most discrimination laws. And we've seen caste-based mistreatment there, um, and that's hard. That's hard for the law to handle right now because there's nothing that basically says that's unlawful. I think the law is slowly evolving and will evolve in the United States, that will at least cover employment. And in
Okay.
education, some of the schools are moving to say caste is, not a basis for any type of differential treatment in some educational situations. So I think it is evolving here, um, but we clearly aren't there yet.
Yeah. So, how will your answer change if, for example, someone gives a race-based slur, for example, to a person who is of African American origin? He abuses that person on based on his race, that he comes from African American origin. Will your answer change or will it remain same?
Now, my answer there would change because there are actually cases like that where black managers have discriminated against other blacks or based upon color. That lighter skinned blacks have discriminated against darker skinned blacks in the employment setting. Now I'm talking about in the employment setting, failing in getting promotion, etc., mistreatment. Their Title VII clearly covers that because it's ultimately because of race or because of color. And therefore it's directly covered under Title VII, whereas caste isn't that neat fit between race, religion, or national origin.
Yeah. So as you answered and you gave context in one of your answers also, that colleges and universities all across US, they are coming in and they are banning caste-based discrimination. For example, the University of California in Davis, Harvard University, Colby College, or even Brandeis University, they have made caste a ground of discrimination in their non-discrimination policies. So, what is the ultimate implication of this move? And do you think that other universities should also follow the same? And how will this move benefit the students who are from these marginalized communities?
Yeah, well, sort of the last part of your question first, it obviously will provide them protections that otherwise they may not have had, absent putting that in for all the reasons we discussed, that a lot of the big federal civil rights laws don't cover caste specifically. Here you have either universities saying, separate and apart from what the federal law says, in our institution, that is not a basis for making a decision. So it empowers those groups in the other castes to be able to have some action moving forward. And I think you will see other universities taking the same steps. And and it sort of goes back to our issue of our discussion about Seattle. I think you're going to see more ground roots. I don't think you're going to get a change from the federal government coming down, passing a federal law. What I think you're going to see are either companies, small organizations, cities, states, and universities making this decision and making it improper from the bottom up as rather from the top down. And you just went through several, fine educational institutions that are doing it. I think others are going to follow that and lead.
Yeah. So thank you so much, Professor Foreman, for shedding knowledge on the topic of today, which was the importance of reservation and affirmative action and the global nature of caste. So all of the things which you touched upon, starting from affirmative action in the employment setting, then we came to affirmative action in the educational setting. Then after that, we came to the Title 7 of the Civil Rights Act 1964. Then we came to the global nature of caste. I think this will help the movement of equality in India, because people from marginalized communities, they will know about the developments in the equality context which are taking place in the United States. One of the things which I personally got to know from today's interaction, which I found very interesting, was that how courts in America, they can order affirmative action in an organization where there is not adequate representation. For example, sir, if we see in India, then even today the people from lower caste communities such as the scheduled caste, scheduled tribe, and the backward classes, they are not represented at the higher levels of administration. They have some representation at lower levels but not at the higher levels. So taking your example forward, if some such kind of an approach is taken by the courts in India, for example by the the Indian Supreme Court, then we can have a better enforcement of these reservation policies. However, reservation in India, which we have, that is a mandatory form of affirmative action, which means that we have fixed quotas, but still because of many varied interests, that is not implemented strictly, and that remains a challenge even today. Thank you so much, Professor Foreman, for joining us today. We are very grateful to you for your time and
I
for
enjoyed it.
giving us so much knowledge. Thank you so much, Professor Foreman. And to all our viewers, please keep watching MNT News Network. Jai Bhim, Jai Mulnawasi, Jai Bharat, Jai Samvidhan. Thank you so much.
Thank you.